Assalamualaikum warahmatullahi wabarakatuh. My name is Nur Azrana Zafira binti Zulzafri and my matric number is 076460. We will be presenting the case of MK Associates Sdn Berhad and Bank Islam Malaysia, Berhad. I will be presenting the fact of the case. So basically, in the case of MK Associates Sdn Berhad and Bank Islam Berhad, the defendant granted the plaintiff an Islamic financing facility based on Buy Bitaman Ajil (BBA) in 1994. Under multiple types of financing agreement secured by charger over several land parcel owned by the plaintiff and its affiliate MK Gulf Berhad. And by February 1998, the plaintiff had fallen behind on the facility, which resulted in default proceeding. These were worn out in 2005 and a liquidator was appointed in 2010. Defendant received redemption amount from the sale or auction of part of the charged land between 2011 and 2012, and the defendant revealed in December 2012 that the redemption amount include 10 million and more in ta'wid, which is late payment compensation, which was computed at a rate of 3% annually between January 2000 and June 2012. The plaintiff contested this charge on the ground that the original BBA agreement did not include ta'wid. The concept of ta'wid was not recognized in Islamic finance at the time of agreement were executed, and the defaults happened before to the Sharia Advisory Council introduction of ta'wid, and the charge was greater than the defendant's actual loss and the outstanding balance.
The legal issues arise in this case is whether the defendant was legally entitled to impose ta'wid under a BBA financing agreement executed in 1994 when ta'wid was neither expressly provided or nor recognized by the Sharia Advisory Council at the time of contracting. Second, whether ta'wid could be applied retrospectively or implied by Bank Negara Malaysia's directive or by custom where the plaintiff's default occurred before the introduction of ta'wid. Lastly, whether the ta'wid imposed was unlawful due to lack of Sharia compliance, particularly for exceeding actual loss and being imposed without prior notice and mutual consent.
As for the contentions, we shall start with the plaintiff first. Firstly, as ta'wid was introduced in 1998 by the Sharia Advisory Council, 4 years after the agreement between the two parties was executed, the plaintiff argued that the concept was not to be applied retrospectively. Further emphasizing this point, as the defendant relied on the notice from Bank Negara Malaysia dated 10 December 1998. The plaintiff contended that the notice referred to the approval of penalty, which is gharamah, and not ta'wid. Subsequently, the agreements did not include any penalty charges in the event of default. Clause 8.1 of the property sale agreement only stated that in the event of default, there must be a declaration of indebtedness immediately due and payable, and/or enforce the remedies under the security documents. Moreover, even if ta'wid was permissible, the amount claimed of 10,384,262 ringgit 88 was excessive, as it exceeded the outstanding balance of 8,958,814 ringgit 41 cents, rendering it an unreasonable amount. Furthermore, Section 8 and Subsection 2 of the Bankruptcy Act 1967 may be applicable if the plaintiff was ordered to wound up, making no late payment charges shall be imposed as it will violate the statutory protection. As for the defendant, firstly, the defendant was entitled to rely on the Bank Negara Malaysia letter dated 10 December 1998, which permitted penalties both retrospectively and prospectively, unless expressly excluded from the agreement, making the imposition of ta'wid permissible. Additionally, the right to claim ta'wid was in the contract between the plaintiff and the defendant, making it contractual right that must be abided by. In regards of the amount charged, the defendant denied charging the 10,384,262 ringgit 88 cents to the plaintiff, which was argued to be an act of mala fide by claiming such unrightful refund, as the defendant was entitled to the redemption sum of 12,758,992 ringgit 37 cents. Furthermore, in regards of Section 8, Subsection 2 of the Bankruptcy Act 1967, it is argued that the section shall only apply to interest, which excludes ta'wid from the statutory definition. Thus, in view of the above, the defendant was justified in imposing ta'wid on BBA facility.
Now, moving on to the ratio decidenda for this case, the High Court held that an Islamic financial institution is not entitled to impose ta'wid where the financing agreement is silent and the concept of takwil was not recognized within the Islamic financial framework at the time the contract was executed. Since the BBA agreements were entered into in 1994 prior to the Sharia Advisory Council's recognition of takwil in 1998, such a charge could not be retrospectively imposed. Additionally, the court emphasized that Sharia principle of justice, fairness, and mutual consent govern Islamic financial transactions. Accordingly, the imposition of takwil requires prior notice to the customer and disclosure of both its impositions and applicable rate, so that informed consent may be given. The absence of such notice and consent rendered the charge unlawful, as property cannot be lawfully appropriated without mutual consent under Sharia principles. Any takwil imposed without this safeguard is unjust and invalid. Lastly, the court further ruled that takwil cannot be implied by custom unless three conditions are satisfied, namely that the alleged custom is Sharia compliant, constant or predominant, in existence at the time of contracting, and not contrary to the express terms agreed by the parties. These requirements were not met in the present case because the practice of imposing takwil was neither established nor prevalent when the contract was concluded.
In judgment, the court found that the defendant imposed takwil on the plaintiff from January 2000 to June 2012 at a rate of 3% per annum. However, the 1994 Al-Ba'i Taman Ajil financing agreements did not include any clause allowing takwil. Moreover, the plaintiff was only informed of the charge in December 2012, long after the sums had been imposed. And expert evidence was presented by both parties. While both experts agreed on the definition of takwil, they differed on its applicability. The defendant's expert argued that it could be implied as a creditor's right upon default, and the plaintiff's expert stated that takwil is limited to actual loss and must comply with SAC resolutions and Bank Negara Malaysia requirements, and must respect fairness, proof of loss, and the customer's capacity. Applying principles of justice, fairness, and mutual consent, the court preferred the plaintiff's expert. There was no prior notice or informed consent, and the conditions for implication by custom or oath were not met. At the time of contracting, takwil was neither recognized nor practiced, and no supplementary agreement exists. As a result, the court held that the imposition of takwil was unlawful, and the defendant has no legal entitlement to charge it under the 1984 BBA financing. Any amounts imposed must be refunded and subject to court assessment, and claims for interest were denied in accordance with Sharia, and cost of 50,000 ringgit were awarded to the plaintiff, and the application was allowed in full. Based on this case, we can see that it highlights the importance of mutual consent, fairness, and prior notice in Islamic finance. While takwil is accepted in principle, it cannot be imposed automatically. It is only allowed as compensation for proven actual loss. Bank Islam Malaysia Berhad was not entitled to charge takwil because the 1994 BBA financing agreements contained no clause, and the concept had not yet been introduced by SAC at the time of contracting, and the court rejected any retrospective imposition, confirming that financiers cannot add new financial obligation after a contract has been executed. Although experts differed, the court ruled that takwil is recoverable only when it complies with Sharia principle, represents actual loss, and is clearly communicated to the customer, ensuring informed consent. The judgment confirms that justice and fairness override implied rights. For future practice, any late payment charges must be expressly stated in the contract or subsequently agreed, must be Sharia compliant, limited to actual loss, and applied prospectively. In short, this ruling protects customer from unfair charge while allowing financiers to recover genuine losses in transparent and agreed manner. That's all from us. Thank you.